Hello guys, welcome to the CHALLA weekly webinar on immigration, and today we've got some really important topics that we're going to cover. Let's just give it a few minutes to allow people to join. For those of you who have been part of our weekly webinars, I want to thank you for attending every week. For those of you who are new, I want to welcome you. I know that this is a very anxious time, so we wanted to make sure that we provided information and updates that you would need. What I would request is I'm going to go over the agenda and how we're going to do the Q&A a little bit different this week. Because I think that previously when we did the Q&A, it was throughout. I think I have taken all the questions that I've been receiving, and so I am hoping to cover most of it in the presentation. And then what we can do is at the end, we can have Q&A. So I see that people are still joining. Let's give it just a second. I'm not going to answer questions till the very end, and I'm going to tell you the process of which we are, just so we can be smart about how we're going to kind of approach the questions to make sure that the maximum number of questions get answered, and they get answered in a succinct, systemized fashion. So I think we can just go ahead and get started. And I know that people are still joining, but I think it's probably a good idea to get going as the numbers keep increasing. So I hope you all had a fruitful week. I know it's a lot to comprehend, that all the things that we're dealing with. But first, I want to tell you about different ways you can connect with me. You can connect with the firm through Facebook, Twitter, Instagram, YouTube, LinkedIn, and Telegram. And for those of you who are joining from Telegram, welcome to my Telegram friends. It's a new chat, and we'll have some details about that shortly, where I try to answer as many questions as I can. There's a lot of questions. We've got about 700 plus strong on Telegram. So, and on that you hear directly from me, or you hear from Kara on the latest changes. So try to connect with us if you can on that. And then if you've missed some of our webinars, please look at our YouTube channel, sign up, subscribe, comment. I'd love to hear what your thoughts are. There's a lot of really good information. And as you'll see from the webinar today, I try really hard to make sure I give you clear direction. It's not just, general information that may not be helpful. It is actually instructions on how to overcome RFEs. It's instructions on how to draft a really successful PERM. So I encourage you to join and subscribe and share with your friends. Okay. The agenda for today, I want to go over the visa bulletin a little bit. Talk a little bit about the difference between the dates of filing versus the final action. What are some predictions that I said DOL, but it's actually DOS, Department of State, did predict on the last visa bulletin how they think the numbers would move and why. What you have to look out for if you're filing under dates of filing versus final action. There's been a lot of questions on CSPA and the analysis. So I think sometimes when I hear a question and we respond, things may be lost in communication. So I wanted to make sure before answering any of the CSPA questions that we outline that very clearly. And then if you're downgrading to an EB-3, there are two ways to do it. Either you amend the existing petition or you file a new petition. So we're going to go through the pros and cons of that. And I think it's important that once we go through that, everyone understands how the PERM is preserved and how you can keep filing petitions, even through a denial, a revocation, and how you can amend from an EB-2 to an EB-3, an EB-3 to an EB-2. We're going to talk about how to leverage previously approved, your previous employer's approved petition, and strategies to consider as you're going through trying to make a decision. And then finally, a lot of questions about the adjustment of status documents, including birth certificate issues. So let's get started. Now, I wanted to go over the Q&A process. We're going to divide the Q&A into these categories. You know, the downgrading from EB-2 to EB-3 with an existing employer, downgrading EB-2 to EB-3 with a previous employer, toggling back and forth from EB-3 to EB-2 if the numbers should advance for EB-2 in the coming months, the CSPA and how it relates to whether you file under final action or you file under dates for filing, and then the birth certificate. The questions will be divided into the sections that I've noted. And what I'll do is after each section, I'll say, okay, go ahead and write your question. You will not write it on the chat. You will write it on the Q&A. And try to write all the questions that relate to that particular topic at the end of that topic. The moderator will look at all the questions based on the various sections, and at the end he'll try to group together like the most common, so people are not asking the same question, so we can get as many answers for you as possible. And so let's get started. The visa bulletin. So this is, let me see if I can kind of move my face, because this is the visa bulletin for the final dates. And as you can see, for the final dates, it's got, for India, for EB-1, it's June 1st, 2018. For 2, it's for employment-based second preference 2, it's September 09, September 1st, 2009. And for January EB-3, it's January 15th, 2010. And these are the final dates for the October bulletin. These are the dates of filing. And as you can see for the dates of filing, it's September 1st for EB-1. For EB-2, it's May 15th, 2011. And for EB-3, it is January 1st, 2015. That's a substantial jump. So what all does this mean? Now, if you know, every month the USCIS will outline whether they will accept the numbers for final dates versus for dates of filing. It changes every month. It's up to their wish and whim. They need a lot of money right now, so they really want a lot of petitions to be filed. So they allowed people to file for dates for filing. And there's another reason why. It's the, I said DOL, I meant DOS, I'm sorry. The DOS predictions for the numbers. So for employment-based second preference, you know, the allotted amount is usually 140,000, 7% per country. This year, as you can see, they have 261,500 and something odd available visa slots. So they think that it will advance pretty quickly. And so the DOS says, in terms of advancement, for first preference, worldwide it's current. For India and China, in the coming months, they predict that there's going to be rapid forward movement. Same thing in the second, same thing in the third. But that all depends on how many applications and how many family members per application are filed in October. So even though they predict it may move rapidly, if we have a record number of applications, you may see November to be very different and not really advance as quickly as they are predicting. And the problem is we don't know. We really won't know until it actually happens. So let's take a look at the visa bulletin. So the visa bulletin, let me minimize my face. There's a difference in the treatment of dates for filing and dates for final action. Some of them are very similar. So when you file a I-140, and an adjustment of status, whether it's dates for filing or final action. The difference between the two, the main difference is the final action means the priority date is current, right? For the dates of filing, the priority date is not current. They expect it to be current. So they're allowing you to file ahead of time. Regardless of whether the priority date is current, the I-140 will be processed. Okay, so the I-140 will continue. And the EAD and AP will be issued, whether it's dates for filing or final action. The final action will also, because an adjustment is, the priority date is current, will start processing the adjustment of status as well. And I always tell people, you've got to remember, regardless of whether you filed for final action or whether you're, for dates for filing, or you filed under final action, once the I-140 is approved and the adjustment of status is pending for 180 days, you're eligible for portability pursuant to AC 21. The dates of filing is, whereas in the final action, it's locked in at the time you file. For the dates of action, it depends on the CSPA age when the priority date is current, when the final action for that priority date comes up. So that's important to remember. So a person may be eligible, but it depends on how long, what the child's CSPA date is. Okay, so to be approved for an adjustment of status, an immigrant visa needs to be available. That means the I-140's got to be approved, and there's got to be a current priority date. So those two things have to happen before an immigrant petition can be available. So when they look at when an immigrant petition can be available, they want to make sure the CSPA date does not exceed 21, right? And remember, for the dates for filing, it is not, a priority date is not available, so it doesn't meet the criteria. And that's why, in and of itself, it doesn't lock it in. You have to look at the dates for filing in conjunction with the CSPA date. And that's what makes it complex. And that's why when I tell people, I say, I just can't answer whether the person will be eligible just by you telling me they're, I'd have to know a number of other things, including how long the petition was pending. So as I stated earlier in my analysis about AGENDA issues, the dates of filing, final action means the priority date is current. It's available to you. And so even if you file under final action, because you filed when the priority date was current, let's say in November or December the numbers retrogress, then the child is protected, it's locked in, okay? For dates of filing, because they're allowing you to file earlier than when the priority date's available, if there is a retrogression, there is no protection. If the CSPA date exceeds eligibility. Okay, how do you figure out a CSPA date? Okay, so for employment-based preferences, it's subtracted by calculating the number of days the petition was pending from the applicant's age on the date the immigrant petition was available, okay? So age at the time of visa availability is when the priority date is current, or when the final action, minus the pending time. So what's the pending time? What is that? The pending time, how to calculate that, is the approval date minus the filing date is the pending time. So the period of time, for example, the I-140, any RFEs, any appeals, all of that is the pending time. And so here's an example. An applicant's mother filed an I-140 petition on February 1st. The USCIS approved the petition August 1st, 2016. So the approval date minus the filing date is 6 months or 180 days. Therefore, the pending time for this particular petition is 6 months. So then you go to the CSPA calculation. The applicant is 21 years and 4 months when the immigrant visa becomes available. That is, a priority date is available. So then the USCIS will then say, okay, here is the month when the priority date is available. That's the age. Let's subtract that by the pending time, the 6 months that the I-140 was pending. So pursuant to that, the child is actually 20 years and 10 months. So they are eligible. And that's how you would calculate the CSPI date. Now, the biggest question becomes, we don't know when the visa availability is going to be, because next month you're going to be filing, most of you, under dates of filing. So even though there's projections that it's going to advance very quickly, there's a big question mark. But here's the thing, even if you don't file next month, the child is going to age out. So, you know, it is a question of whether you're willing to take the risk at the time. So, as I said, the CSPA date, when the adjustment is being reviewed, the primary and all the beneficiaries' petitions will be reviewed only when the priority date is available. Okay? And so if you filed under dates of filing and the priority dates move quickly, then you're fine, you know, depending on where, how long of a CSPA, you know, process you have. There were times when the I-140 was taking 11 months, they'd be an RFE. So, you know, it would be much longer. And I know that people often opt for premium processing because they want to make sure that they can get extensions on their H-1B. That's why it's good to file your, if you've got children that are older, it's good to file your I-140 under regular process so you can avail yourself of greater pending time and increase the CSPA date for your, or decrease the CSPA date for your children, because even if the I-140 is approved, you have to have a prior, there has to be an available visa number for you to really leverage it. So these are some considerations people should have as they're assessing what they're going to do. And again, this is just re-emphasizing that in the final action, it does lock it in because you're filing when a priority date is available. And so even if there is an age-out issue, it's not a problem, and the numbers retrogressed. If you're filing under, you know, the current you know, dates for filing, the CSPA dates are not locked in. There we go. Now, there is a lawsuit on the disparate treatment between age-outs, and you have to take this in strive with the fact that if there's a new administration, we get a Democratic Senate, Democratic House, and a Democratic President. You know, visa backlogs are going to be probably one of the biggest issues that they take up. I know for a fact that I've spoken to the Biden campaign, immigration reform is going to be one of their hotbed issues that they take up pretty quickly. So when you're deciding to downgrade with your current employer, you got an EB-2 approved. There are two ways to do this. One is amending your existing EB-2 to an EB-3. The other is filing a new petition. Now, to amend, when you amend, that process is supported by the USCIS Adjudicator's Field Manual. So that means that there is no way, if everything else is prepared correctly, that the USCIS would say, I'm not going to do this, because they've just updated their USCIS adjudicators manual, and it has clearly in there that you can amend from one category to another. Now, in previous years, immigration attorneys and the American Immigration Lawyers Association has supported the process of filing. They've taken, because this is all prompted by something called the 2007 Newfield Memo, and that was partly partly written because in 2007 for Chinese nationals, EB-3 had advanced so much more than EB-2. So Newfield, who was the USCIS director at that time, wrote a memo and said, and he was speaking in very general terms. And so he talked about how you could preserve the, and this was right when PERM was introduced, pretty close to that time, how you can preserve your PERM in certain types of cases. And he says, these instances may occur, okay? As a lawyer, when you hear may occur, that doesn't mean it must occur. That means here are some examples of how you can preserve. So at that time, we took the American Immigration Lawyers Associations, and a lot of us filed new petitions, preserving, so you have the EB-2, and then you also have the EB-3. I would now think, because this current USCIS, I mean, we hope we'll have a new administration in January of 2021, but we don't know. So even with the Trump administration in office, I would opt for the amend, right? And if you file for the amend, I am with each petition going to put a copy of their USCIS manual, their manual that they have to use to review cases, and say, hey, pursuant to your manual, we can amend. The problem with amending is that you've now changed, you've converted effectively the EB-2 to an EB-3. But that doesn't end the all the things you can do with the petition. You can, if EB-2 advances, you can amend again. You'll have to submit new filing fees, but you can amend back to EB-2. If the EB-3 is denied, you can refile if you've amended. If you file a new petition, your EB-2 and EB-3 exist. So you'd already have the EB-2. But I'm going to talk about this because it seems very complex and convoluted in just a second. So 2007, that's when the PERM came out. And the PERM rule is you have to file, the original PERM has to be filed in order for it to be preserved and not die. Within 180 days of its certification, it has to be filed for an I-140. As long as it's filed for an I-140, within that 180 days, it preserves it, okay? If it's not filed, it's a dead PERM. It's just got to be filed. So they say that it is preserved, and that's where they say these filings may occur if there's a successor in interest and an employer change. If the petitioning employer wishes to file a new petition subsequent to the denial, revocation, or abandonment, and the labor certification was not invalidated because of material misrepresentation, you can refile as long as it was originally filed in the 180 days. It gets denied. You can still use that PERM as long as it was filed in the 180 days. And the employer, because you changed employers, revoked it, that PERM is still preserved. You can file a new I-140 using that PERM. And then they go on to say that an amended petition can be filed to request a different visa classification than requested in the previous petition. And there's no limit to how you can do that. So there's a term, called toggling. So at this point, I forgot to tell you, if you have questions about, because we've covered EB-3 downgrading with the same employer, and we've covered CSPA, the Child Protective Age Out questions. If you've got questions related to that, please start listing those questions on the Q&A. And then at the end, we'll take them. Like I said, I'm not going to take your questions on chat. You've got to have them on the Q&A. So because we have, this is the memo I'm talking about, because we have this 2007 memo, and now it has been formalized in the USCIS manual, for an amended petition, we can point to this. And that means you can continue amending. If your petition previously, it was with a previous employer and the employer revoked it, you can point to this and say, but the PERM is still alive, it's been preserved, so we can use this for a new filing. You still need to make sure that you meet all the requirements of the original PERM, okay? Even if you are downgrading from an EB-2 to an EB-3, you've got to show that you meet the requirements for the EB-2, the PERM that was originally filed. And then you amend, you know, for the EB-2. And then you also have to show that, you know, and I'll talk about this in a second, anytime you file a new I-140, whether it's amend or original, you have to show ability to pay. So those are two things that need to be addressed. Now, the EB-3 is a professional who holds at least a U.S. bachelor's degree or foreign degree equivalent. So if you have a master's degree, you at least have a bachelor's degree. So the mere fact that your EB-2 required a master's degree does not negate your ability to get an EB-3, because you meet the minimum threshold. The minimum threshold is a bachelor's degree. But you have to have the equivalent of a bachelor's degree. And it is noted in the regulations, if you have a master's degree, especially a U.S. master's degree, it is deemed that you've got the equivalent of a bachelor's degree. So now we're going to talk about your previous employer. As I stated when we talked about preserving the PERM, you could go back to a previous employer if they're willing to support your application. It must be a bona fide offer of employment. That means you have to intend to go back. You pay, they ask you for a fee, and you're doing this by paying them something, you will be found out, and it is visa fraud. You'll be kicked out of the country, and you'll be never permitted to come back. So it's got to be a bona fide job offer. You don't have to start working for that employer until your green card is approved. No matter what anyone tells you, you don't need to have an existing H-1 with them. It would be filed as prospective employment. But what becomes the issue? So, as I told you earlier, you've got to prove ability to pay. So let's say the PERM has a salary of $60,000. I'm just putting this out there as the prevailing wage. And your current employer has been paying you $70,000. There is another memo where the USCIS states that if the employer has been paying the employee the proffered wage, that means they have demonstrated ability to pay. That's it. So it would be when you're doing the amendment with your current employer, there would be no problem showing ability to pay because they have been paying you. But that's not going to be the case with a previous employer, right? Because you're no longer getting salary from them. So the other way of showing ability to pay is looking at the net income of the employer. The net income of the employer has to exceed your salary. Net means that is gross minus expenses. That's your net income. So if the employer's net income is greater, is $60,000 or greater, he can demonstrate ability to pay for your petition, even though you're not on payroll. Okay? Let me go through that again. If you're filing an amended petition with your existing employer, and the salary you currently are making is either at or above the prevailing wage stated on the PERM, they have demonstrated ability to pay. If you were filing a petition with a previous employer where you are not currently getting the salary, and you're not required to because you're filing this petition as prospective employment, then you have to make sure that there's no issue on ability to pay. And the way in which that old ex-employer has to demonstrate it is showing that the net income on his latest tax returns, and you have to show, the thing is you have to show ability to pay from the date the labor cert was certified until the date you're filing. So it depends on how far back that is. So you have to show every year from that time, and the net income must exceed the proffered wage. Here's some strategies you've got to think about. So there's something called interfiling. If you've got an EB-3 and an EB-2, you're filing under the EB-3, and then next month the EB-2 advances further. You can always, you don't have to file a new adjustment. You just have to do what's called interfiling. You take the approved EB-2 and you send it up and say, here's the EB-2. You can do that even if you're trying to amend back. You file, you're amending back, and then you're advising the USCIS that I'm amending, I filed, I went from EB-2 to EB-3. Now EB-3 is advanced. I'm going to amend back to EB-2, and I'm doing this through interfiling. You got to make sure that if you're using a previous employer that you have, the issue of ability to pay has been assessed. And then remember AC-21 portability. Yes, you have to have the intention of working for the new employer if you're using a previous employer's PERM. So I would make sure that you have some documentation, some email going back and forth saying that you do intend to join them. And I don't want anyone on my webinars to pay their previous employer any money for the ability to use that, because people will find out. I have been doing this long enough to know that it will be found out, and it is visa fraud. It is bad for you, and it is bad for your employer. Please do not engage in that. But if you say to your employer, I will join you when my green card gets approved, and then later you change your mind, because once the I-140 is approved and the adjustment's been pending for 180 days, you can change to another employer through same or similar employment. That's okay. But you can't start out at the beginning and say, I'm not going to join you. Just file this because I need it. Remember, if the EB-3 is approved, you can refile the I-140. But if you don't have another I-140 approved, the adjustment can get denied. So you will forego all your adjustment fees. One of the newest things that has come up just yesterday, it's like it was a birthday present for me, a U.S. District Court issued a nationwide injunction on the increase in filing fees. So that's great news for everyone. The filing fees won't be increasing October 3rd. We encourage everyone, at least who is filing with us, to send us the increased filing fees. As lawyers, we have something called a trust account. I am required to have a trust account by law. I would get into serious trouble if I did not have. I could lose my license. So the trust account is a non-interest bearing account. I'm not making any money on that. It cannot be an interest bearing account by the the bar ethics. So lawyers cannot make money off their clients' money that's in this trust account. So we've told our clients to send in the increased fees, so it sits in our trust account, because if something should change between now and the date that we're going to file, and the new fees do go into effect, I don't want there to be a delay because we're going back and forth. And then once we file, we'll just send you a check for whatever was not used. So that's the process. So it is remembering that your benefit in all of this is filing the adjustment, even though you're filing for dates of filing. We don't know, especially with EB-3 or EB-2, when you're going to get that opportunity again. The queue is pretty long, and there's going to be a lot of people filing. And so there's no way to predict how this is going to go forward. So you have to think of that. This is the benefit for me, is the ability to file the adjustment in October. Now, if you've got kids that are going to age out in a couple of months anyway, they're going to age out. And if, for example, the EB-2 advances, you can always amend it back to EB-3 and interfile that with the adjustment. That's not a problem. Because remember, we know that 15 days prior to. Now, an amendment can never be premium processed, even if it's not with an adjustment of status. Because remember, we don't have the original labor cert. So we have to request the USCIS to get the original labor cert and pull it from the previous file. So if you all, anyone that has questions relating to joining a previous employer to leverage the adjustment filing, please ask those questions now on our Q&A. Now we're going to go to the adjustment of status documents, and they're pretty straightforward. We've got a link if you would like it, 2 photographs, government issued documents, and so forth. The biggest issue people have is the missing birth certificate. There's a difference between a missing birth certificate, that means you don't have it, and if your birth certificate has a typo. There is a difference between a missing birth certificate and if your birth certificate has a typo. If you don't have a birth certificate, then what you have to first demonstrate is that document is unavailable, right? That primary document is unavailable. And then you're permitted to issue secondary documents. So in order to demonstrate that the primary document is unavailable, you need to get a letter from a record-keeping body in the locality of your birth, okay? You need to get a certificate of unavailability from the record-keeping body of your birth, and then you should submit as much of the secondary evidence as you can. What has worked? Because people tell me, oh, I filed my green card 15 years ago and I just used my school leaving certificate. Well, because I've been doing this for 25 years, there was a time where the USCIS would not accept just the school leaving certificate. So the gold standard seemed to be, if you don't have any birth certificate, is to get a certificate of unavailability, and I'll show you what that looks like in a second, and 2 affidavits from people who have first-hand knowledge of your birth. So, and I will give you a copy of that as well. It has to have the affiant, the person, let's say it's your mom and dad. It doesn't have to be your mom and dad. It can be your aunt and uncle. Anyone that, they've got to be older than you, otherwise they can't have first-hand knowledge of your birth. But it can be any relative. And it's got to state their name, their address, their date and place of birth. The reason why the place of birth is they've got to make sure that these people are older than you. The relationship to you, and how do they have firsthand knowledge of your birth. In addition to the certificate of unavailability, the 2 affidavits, you can also provide your school leaving certificates as additional matriculation documents, as an additional document. But And so this section is just if you've got missing birth certificates. So if you've got missing birth certificates, if you have any questions and you're not clear on what you need to provide, you can ask those questions now. The second is you have a birth certificate, but it contains a typo, or you obtained the birth certificate 10 or 15 or 20 years after you were born. So the birth certificate is there, so you don't need to issue a certificate of unavailability because it is available. But what you want to do is, if it is an incorrect birth certificate, you want to explain perhaps a discrepancy. There was a typo issued at the issuing authority. So for example, my name is Lakshmi. Let's say my birth certificate said Laxmi. Both ways are ways to spell Lakshmi. So you would show the birth certificate that said Laxmi and just state that there are two ways to spell Lakshmi. They incorrectly spelled it Laxmi, but I spell my name Lakshmi, but it is indeed my birth certificate. And then you would get two affidavits. I would get affidavits from someone that can say, yes, this is the correct spelling of her name. And then in addition, if you've got all these school certificates that show it's Lakshmi, that's a great way to show the discrepancy or the typo or the incorrect information on the original document. The same holds true if it's a date that is incorrect, if it's the place that's incorrect, whatever incorrect information it is, you would show that. Then, if you obtained your birth certificate much later than your date of birth, you kind of want to explain why. It could be that maybe, that there wasn't a strong record-keeping body at the time you were born. If you can get a letter from the registrar saying, this person was born in 1982. In 1982, we weren't really keeping good records, but we did issue him a birth certificate in 1992 when we started keeping records. And then get two affidavits from people who have firsthand knowledge and any school records that would corroborate with that. Now here is a sample affidavit of birth. If you're getting it from India, make sure it's on stamp paper. If you're getting it from a relative who's in the US, just have it notarized. So you would say the affidavit of birth on behalf of whatever your name is. The name of the person, Lakshmi Challa, I'm a citizen of India. I'm currently residing in some address in Andhra Pradesh, India. I hereby state that the following is true and accurate and to the best of my knowledge. I, Lakshmi Challa, am the aunt, mother's sister of Jane Doe. This relationship gives me firsthand knowledge of her birth. I was born 1964, September 29, 1964, in Pittapuram, Andhra Pradesh. I have firsthand knowledge of the birth because of what? I went to her naming ceremony 10 days after her birth. I was there and I witnessed, the firsthand, witnessed her birth. Whatever the reason may be, that how does this person know about your birth? Then you state that in the month of, so the person was born January 1st, 1982. So on January 15th, 1982, we had the naming ceremony in, Kakinada, Andhra Pradesh, and where the beneficiary was born. So then you say Jane Doe was born in Kakinada, Andhra Pradesh, was born on January 1st, 1982 in Kakinada, Andhra Pradesh, And then Jane Doe was born to John Smith, the father's name, and Julie Smith, the mother's name. And then you have it dated, and whoever the affiant is, that means me. Here we had me being the affiant as the aunt. I would sign and have it sworn, either notarized or on stamped paper, and have that done. When you're filing the adjustment, we don't need the original. We only need the copy. And so you can submit the adjustment application with a copy, and just so make sure that you have the original for your interview, subsequent interview. So right now, because we're in this rush, just make them take a picture of it, try to make sure it's a clear picture, and then have them email it to you. That will be enough for the adjustment filing. Let me say it again. A copy, a clear copy, is enough for the adjustment filing. Just get the original for the interview. Now, same thing with the certificate of unavailability, and this is how a certificate of unavailability is. They have the official letterhead, they usually have a stamp, you know, and it's the registrar, issued by the Registration of Births and Deaths Act. This is to certify this person made a request in the municipal record of births for the year whatever, and we found that it was not registered and it was unavailable at that time. You just need a copy of that. You bring the original at the time of your interview. The question also comes up, what if I can't get the certificate of unavailability in time? So the supporting documents, the I-140 and documents relating to that, are very critical. Making sure your attorney says, please request the PERM if you're doing an amended or doing an amended petition, is very critical. The subsequent documents relating to birth, marriage, and all those other things, I would submit whatever it is you have, but you would not be denied because you didn't have it at the time of the adjustment. The RFE will be issued, but try to submit as much as you can possibly gather. No, it's more important to get the filing in with the critical documents than it is to, you know, then waiting to file this and having that to be a problem. Like I said, all petitions must include a I-994, because remember, after October 13th, the I-45 will be rejected without the I-944. It's got to be included for each person that's filing an adjustment. Each person or child in the family that is filing the adjustment. And there's a lot of complicated, there's a lot of documents that are required with the I-944. Those are also the documents that are required for an I-485. And I think we have a link that would kind of highlight how we can use them for both with our firm. Additional reminders, I put this up on hold by courts. There are forms that have changed, so you want to make sure you've got the most updated forms. There are some changes that are coming up in the pipeline, I am sure. Every week there is something. We don't try to preordain what the agenda is going to be for the following week, because I want to address, and I'm pretty sure there's going to be more questions on this adjustment as we move forward, but we want to address whatever the latest changes are. So we try to, you know, make sure that it's more up to date. But if you register for our webinars, you should be getting our updates. And if you're part of our Telegram group, and if you are not part of the group, here's the invite that you can use to join our group. I try to put the agenda up on that so everyone will know. And I'm trying to update that with useful tips and information. I'm thrilled to say that Our community has grown to about 700, and let's see if we can get it to 1,000. I'm sure with all of you, we can. And that way everyone's getting the information. We will be uploading things like the CSPA information, the sample affidavits of birth, the sample certificate of unavailability. It will be only available on this forum. So if your friends want to join, please have them do it. This afternoon, I will spend some time answering questions on that and trying to get to as many of you as I possibly can. But, and thank you for promoting it as much as you have, but I'd really like to see us get to the 1,000 mark this week, so we can, because otherwise I am talking to people on various forums, so it would be nice if we could have it in one place. And here is the other ways to connect, and you can review the recordings on the YouTube channel. I think right now we're ready to take Q&A. Is Shaker Challa in the house?
Yeah, I'm here.
Okay, great.
So
I see there are about 125 questions.
In the chat, or is in the
No, it's in the Q&A.
Q&A.
I told them we wouldn't respond to questions in the chat, that it would be just in the Q&A.
Okay, so should I start from the top? Or,
yeah, I sent you how we're trying to divide up the questions so we can group them.
Will they can unmute themselves, I suppose, right?
Well, no, you can ask the question because I told them to write it out already.
Okay, so I'll just ask the question that's on the...
Yeah, like the most common question they probably would have asked. I know it's hard, it's 100 and...
Okay, I'll just start from the top. I think I heard you saying something about birth certificate. So let's start with that. It says, what if there is a typo in my mom's name in my birth certificate?
Right. As I stated in the explanation, if there is a typo, that's different from when you don't have a birth certificate. You want to explain why there was a typo, right? And then you want to submit secondary evidence showing that what the correct thing should be. So if your mother's name is Padma, P-A-D-M-A, and it was spelled P-A-D-M-E, and all your other documents, like your school leaving certificate, your 10th matriculation, any other documents, if you've got an Aadhaar card, any other documents you have show P-A-D-M-A, then you want to get two affidavits. Get an affidavit, one from your mother, maybe one from your father, saying that there was just a typo, they made a mistake, and then you submit all the other documents with the correct name so that you're connecting them together. And that is the same thing if it's a missing date of, if it's an incorrect date of birth, if your name is misspelled, if your father's name is misspelled, if the place where you were born were misspelled, or they listed it incorrectly. For any of these, it's the same answer.
Okay. So the next one related to that, it says, I'm born in 1979, but got the birth certificate in 2018. Do I need to have additional documentation to support the date of birth?
Right, and I think I talked about that as well, that if you've got a if your date of birth is much later, they are not accepting that. So you wouldn't be able to issue a certificate of unavailability per se, but what would happen is that, you would have to explain why you didn't get it in 1979. So if the registrar is willing to give you a letter saying, we really didn't issue them in 1979, but we are issuing them 10 years later, you would submit that along with two affidavits and any additional information about your register of birth.
All right, next one is in the birth certificate, instead of family name, initial is printed. In this scenario, do we need to take an affidavit? I think you said you have to take, right?
Yes.
Yeah.
It doesn't matter what the typo is.
Okay, and then
anything. Yeah. So for any of them.
The next question related to that says, if the name is different on birth certificate and passport, then in that case, the affidavit should match the passport, the birth certificate.
Well, why is the name different? I mean, so you've got the birth certificate. What was your school certificate? What was your 10th matriculation? And then why is the name different on the passport? So you would have to explain that. If, let's say it was different on the birth certificate, but you know, your school leaving documents, all your other documents are the same as your passport, you would want to, you would want to explain why. So that happens all the time when you have a long name. So my name is Mahalakshmi Kumari Galakota was my name at the time of birth. That's a lot, it's a mouthful. Let's say I decided all throughout my life that I'd just be Lakshmi Galakota. So my school certificate said Lakshmi Galakota, my 10th matriculation said Lakshmi Galakota, and my passport said Lakshmi Galakota. The only difference is my birth certificate says Mahalakshmi Kumari Galakota. Then I would just explain that, and then I would get affidavits and the school matriculation and everything else to support it.
Okay. So another related one is, it says the birth certificate is in a regional language. So is the affidavit enough, or does the birth certificate need to be translated, certified
Right.
and translated?
When you have a document that's not in a native English language, you need to get that document translated, and then you need to get a certificate of translation. And you don't have to get it done from, and I'll try to, if you join us on Telegram, I'll try to post an example of a certificate of translation. Anyone can translate it that has knowledge of both the native language and the English language. So you have a friend who speaks, let's say the native language was Gujarati. You have a friend who can attest that they know how to read Gujarati and know how to read English. So the certificate of they would translate it, and the certificate of translation would say, I am, you know, I speak, not conversant, but it's, I've got the command of both English and Gujarati. So, you know, I am attesting that I have, under penalty of perjury, translated the documents true and accurately as to the best of my ability. And so you would attach that.
All right, I'm going to have the last question on this birth certificate. There are a couple of general questions. One is like, can birth certificate be manually filled with ink? It doesn't matter, I guess. A birth certificate is a birth certificate.
Why? I mean, was it filled later? Did you fill it, or did the is that how the how it was issued? That would be my big concern. If they just gave you a blank and you filled it in, then you need to have secondary evidence, and I would include that anyway. And with relation to all the questions on the birth certificate, remember that you don't need to have all the evidence at the time you're filing your adjustment. Make sure that your attorney's office knows what the discrepancy is, so they can at least point to that in there. They should be putting together a very detailed cover letter to address all the issues and nuances, so they can do it in that. But you don't need to have all the evidence at the time of filing, but just know you're going to get an RFE.
All right. So then just move to the next category, just to address a wide number of questions from viewers. So this is on I-485. I'm eligible to file at I-485, but unfortunately need to leave the current employer in next 90 days. Would you please give advice if I need to restart the PERM process again with a new employee, or any other options?
Right. So if you are ready to, if you're leaving the employer in the next 90 days, first, is the employer willing to support your, you know, your filing of, I don't know whether you've already filed an I-140 or you filed a 485. And the other thing is you may want to get started with the new employer just as a safety net. Number three, remember when the I-140 is approved and the 485 is pending for 180 days, you get to leverage what is called AC-21, so that you would be able to change employers as long as you're working in same or similar employment.
All right. Next one is again related to 485. Says I moved from H1 to H4 recently. I still have an approved EB-2 140 with my H1. Can my employer file for EB-2 to EB-3 downgrade? But a follow-up question is, I think, if I wait for my EB-2 to become current 5 months short while I'm still on H4 and file for 485 when my date becomes current, does my employer still need to prove ability to pay when filing 485?
Okay, so if you are not going to do a downgrade when you file for 485, no, you don't. If you are going to file any I-140 petition, whether it is amended, new, you have to show ability to pay from the time the labor cert was certified until the filing of the I-140. The 485, sometimes they won't really address ability to pay if you're just filing an I-485 without the I-140, because the I-140 has already been adjudicated, so you're not downgrading or you're not converting. But if you're filing the I-485, sometimes they want to see recent pay stubs, they want to get confirmation of employment. Those are the types of things that may come up, but it's not necessary. But if you file an I-140, you will have to prove ability to pay.
All right. So next one is, do we need I-485J form from employer while submitting I-485 application? This process takes 2 to 3 weeks from employer, and this can cause hindrance in submitting application on time for EB-3 at least.
Right. Why would that take so long to get it from your employer? Let me check, and I know the I-994 would be rejected, but I don't know. I don't think that the J form is one that they would reject, but I want to confirm before I let you know. So we will, like I said, these are things that if you're on the Telegram group, I can just blast to everyone to give them an answer.
Okay. The next one says, my I-140 got approved with my previous employer, and the company which my I-140 got approved got merged with another company. Can I still file my 485?
If it's a successor in interest, yes. A successor in interest is when the company merges or acquires another company, and it either takes on the assets and liabilities of the company, or it takes on the assets and it puts in the immigration files that it takes on the immigration liabilities. If it does that, then yes, you can do it.
The next question is, if H-1B transfer with new employer is in process and also eligible for filing I-485 with current employer, what are the options?
Well, your H-1B transfer doesn't really impact your ability to file the I-140. You would have been getting the salary from your current employer even now, because the transfer you said is in process. And so, if you file the I-140 quickly, you'll be able to demonstrate ability to pay with this current employer. Now, and so you can file the I-140 and 485. Now, if you leave the employer may revoke your I-140 before it gets approved. And there's some timing nuances with that. So that's the only thing that you would have to look out for. You may want to stick with that employer for a little period of time and then change your employers once you're able to port.
Okay. The next question says, my daughter, 12 years old, is in India and was told I can't file her I-485. If I file now for myself, when can I add her? What other scenarios I have to add her AOS?
Right. So there are two things. One is consular processing. One is adjustment of status, right? Consular processing is when you obtain your green card visa or immigrant visa in a consulate abroad, like you did your H-1B. Adjustment of status is when you're in the US and you are adjusting or changing from your non-immigrant status to permanent residency. If you were not in the US, you cannot adjust. You have to be physically here. Now, what you can do is if the child is on an H-4, you can, at least in the I-140, indicate that your child is going to consular process. Now, remember, the presidential proclamation has restricted consular processing, and quite frankly, most of the consulates are not really functioning on full capacity yet. So that wouldn't be able to take place. But if, let's say, your daughter comes back to the US in December, there's got to be an available visa number for her to be able to adjust at any point, because if the visa number is retrogressed, then she wouldn't be able to avail herself of that. If they do not, then she can. So she can be included in at any point when the visa numbers become available, and you can concurrently have it listed as a consular. That doesn't stop her from later coming in and filing for adjustment.
Okay, related to I-485 AOS, is I-693 required to be filed with I-485 AOS?
It just depends. Not everyone is required to file that form. It's only, in certain circumstances. So if you've changed employers, it's, oh, you mean, talking about the medical exam. Okay, I was thinking of something else. The medical exam, it's not mandated, but it won't get rejected without the medical exam, but you kind of want to indicate why. And I know that, I know in previous surges when we had, I think it was like, I don't know if it's 2003 or, there was such a push to get adjustments filing that the designated immigration physicians were booked. You couldn't get an appointment. So if that's the case, I would say, I didn't get an appointment. Here's proof that I do have one. I'll get it at a later date. But it's not required. It's not mandatory. You will get an RFE, but it's not mandatory.
Okay. We're not doing the raising hands thing, right? We'll just read the questions from the thing.
Well, do you think it would be, I didn't know we would get so many questions. We've got 62. If you think you've grouped enough of the questions, and we can get people to raise their hand and ask.
There are a couple of people who raised their hands, so I just wanted to make sure that, So let me try, but I just want to tell everybody, don't raise your hands now. If you already raised, that's good. Let me try to get the answers done, but let's see. The first person on the list, Ravi Shan. If you hear me, can you unmute yourself and ask your question? Because I don't think I can, looks like I can't unmute him.
Let me see.
But it says chat, but that's about all I can.
No, I think you have to go to participants.
Yeah, I did. And then the participants, I got the attendees and panelists. So in the attendees, I don't see, unless, let me expand and see, but I don't see the option where I can, it only shows raised hands, that's it.
Okay. So who's the first one? I can allow them to talk.
Ravi Shan.
Ravi Shan, okay. Okay, Ravi.
Okay, now I think now I can do it now. Okay, I had to stretch it. Okay, go ahead, Ravi.
Yeah, thanks a lot for taking my call and then making it so simple for all of us. So a question is, I have 6 employers who are ready to file. One is in EB-2 and one in EB-3. My current employer, PERM, is in process. So I'm in a situation where I have to choose, or can I just go ahead and file it with both employers for the future employment perspective in the past employers?
Right. You can, right now what I would do is the EB-3 current?
No, in both cases, I'm sorry, my priority date is September 2010. Both I'm in the chart 2 only, filing date only, EB-2.
Okay, got it. So I would go ahead and file with the EB-3 first. And then because, well, I guess for EB-2, you don't even have to EB-2 is 20, you said 2010?
Both are same, yes, 2010 September.
Okay. So, they are saying that EB-2 because there's a lot of people that are going to have to downgrade because they don't have even for dates of filing, their EB-2 would not be eligible. So from a strategy point of view, it may make sense, since you've got an EB-2 that's eligible for dates of filing, go ahead and file it for, and which one is the earlier priority date?
Right now, EB-3 is in, the final action is in January 2010.
No. Which one did you file first?
Oh, first EB-3, then EB-2, 2 different employers.
Okay, but it's the same priority date because you ported the priority date?
That's right, ma'am.
Okay, so I would go ahead and file with the EB-2 in anticipation that the EB-2 is going to advance or may advance down the road in November. You can always interfile with the EB-3 approved petition at a later date.
From 2 different employers. So at what time I can go back to the, does it raise any red flags if I change the employer from, you see, both are my ex-employers. I'm currently employed to the different employer. So,
right, so what you want to do is the only issue I would say is you want to make sure that if somebody questions you, okay, that there's no misrepresentation. So the requirement is it has to be a bona fide offer of employment. So if there is a correspondence between you and your employer, and he says, I want to join you back, the arrangement is that you will join him once the green card is approved, because that's a requirement. And you both exchange emails and have some details about it, and you have that on file, right? Then in case it's ever questioned, you can show it's a bona fide offer of employment. Here's the evidence.
Okay. Thank you, ma'am. At what time I can switch from, I don't mean to, but let's say EB-3 is moving faster, let's say in 2 months from now, and then that moved to final action date, but EB-2 is still in filing date. At what time I can move to the another employer, B? So
right. So you said your PERM is currently in process with a new employer, right?
That's right.
Yeah. So when you do that, you can go ahead and you should actually, since it's in process, you should go ahead and try to actually get one under EB-2 and EB-3. It can't be the same PERM, but you can have 2 PERMs. And then file one for EB-2, file one for EB-3, and then, or file it for EB-3, and then because you've already filed one for EB-2, and you can interfile it. So if EB-3 advances, you can always, because your adjustment, once you filed it, you don't have to, just because the numbers advance and you want to change what classification you're getting your adjustment in, you don't have to refile your adjustment. You just have to do what's called an interfiling. You have to let them know that you have an approved I-140 for that other classification.
Even though it is employers?
Correct.
Okay.
Thank you, ma'am.
All right, I'm going to pick up questions from the Q&A just so that, we can address more questions, and we can come back to raise hands. So one question is, if you downgrade to EB-3 from EB-2, and if you work on EAD, can you use your approved EB-2 I-140 to apply for 485 GC? If EB-2 becomes current.
Right. So if you're amending your EB-2 to EB-3 to file this current, and I wanted to say something for the guy who asked the question earlier. I just want to make it clear. Once your I-140 is approved and your 485 is pending for 180 days, and then there's a retrogression or something happens, that's when you should do the interfiling if it's another employer. There are greater, there may be some issues in which you can do it before then, but that would be the safest bet. I just want to make that clarification. So in this case, so as I said, there's something called toggling. Toggling means you can keep going back and forth. So remember, if you've got an EB-2, for most purposes, it should also qualify for an EB-3. DOL doesn't care how you file with USCIS. DOL just wants to make sure that DOL's requirements are met. So if you file if you convert an EB-2 to an EB-3, you file for an amendment. Then EB-2 becomes current. Then you file for another amendment from the EB-3 to the EB-2. Or another thing you can do is, in the interim, get a new PERM started for the EB-2 classification. And that way you're not going back and forth, but once the EB-2 is approved, you'll have them both in hand and you can just, submit them.
All right. The next question is, can we do EB-3 downgrading with different employer even if earlier approved I-140 EB-2 has been revoked after 180 days of its approval? Can we do EB-3 downgrading with different employer even if earlier approved I-140 EB-2 has been revoked after 180 days of its approval?
Right. So I guess the way the question is, I would have to know. So I'm going to answer it in two ways because I'm not really clear about the question. So if the EB-3 was revoked, you'd have to file a new EB-3. But you can't use whatever the PERM and I-140, the priority date can port, okay, once the I-140 is approved. Even if it's revoked, denied, whatever. I mean, sorry, not revoked, but even if it's revoked, the I-140 can port, okay? That's one issue. But the PERM and the I-140 can only be for the employer who petitioned you. Now, if he withdrew it, if he revoked it, it still may be, the PERM is still alive, so you may be able to leverage it. But you can't use that PERM for a different employer. All
right. The next one says, I'm on EB-2, but to change my employer, how can I file for change of status for GC? My I-140 from previous employer is February 2011.
Okay. You can do it if, like I said, for prospective, if your previous employer, if you're willing to work for them after your green card is approved. That means you have that intention at the time of filing your I-140. And there is no problem with the employer demonstrating ability to pay. You can use that previous I-140 to downgrade now and file your adjustment.
All right. There's a question that says, I have EB-3 140 and upgraded to EB-2 with 140 for the same company. My EB-3 filing date is current. Can I use my EB-3 I-140 on filing I-485, or I have to use EB-2?
Right. So you're, as long as you didn't amend your EB-3, that means your EB-3 is still valid. You have an EB-3 I-140 and an EB-2 I-140. You used your, so now you can, if your EB-3 is current, you can use your EB-3 for advancing. If you amended your EB-3 to EB-2, and you don't have two, but you just have one that you've shifted, then you've got to amend back. But if you haven't amended and you've got 2, then you can use the EB-3.
All right. Next one says if one has an approved I-140 in both EB-2 and EB-3 from same employer with priority date of October 2010, advise the recommendation which category to go with.
I think I'm trying to remember what the priority date is for, I can't remember off the top of my head, for EB-2, for the dates of filing. I know I have it on here, hold on. I can never remember them off the top of my head. Okay, here it is. One second. I'm just trying to pull it up so I can. There we go. This is the final action dates. So what's the date that they have?
October 2010 is what the question was.
October 2010. And which category?
Both categories.
Oh, both of them. Okay. October 2010. So both of them would be subject to the final dates instead of the date of filing. So I would do it in EB-2 because we're going to have a lot of people converting in EB-3. So I think that would be the best bet to do it in EB-2.
Okay, the next question is if spouses is eligible for filing I-485 based on current filing date and my EB-2 I-140 priority date is coming under EB-3 filing date, is it advisable to downgrade to EB-3 from EB-2?
Right, so anytime you're assessing whether to downgrade, you want to look at a number of things. You want to look at, because the benefit is the adjustment. Okay, the benefit is the adjustment. They're going to be going back and forth for a while, and we don't know how this is going to play out. So if you want to get the benefit of filing adjustment of status, and you don't think that there's going to be, and it's your current employer, so you don't think there's going to be a problem with ability to pay, you might as well do it because you can always amend back up, right? I mean, the dates are going to advance, but we don't know how many petitions are going to be filed this particular month. So if you file your, if you're eligible to file for EB-3 this month, it is just, and we don't know what November is going to look like, December is going to look like, and January is going to look like. That has to be an individual decision as to whether you want to avail yourself of the adjustment. Because if you file the adjustment, remember I said the benefit is the I-140 is going to be processed. Once that's approved and it's 180 days, then you can change employers. Once you file, you get your EAD and AP. That's another benefit. So there's a, and they are looking at taking away the H4 EAD. At least this is a way that your spouse can get an EAD that is not under scrutiny to be revoked. So these are the kinds of things you have to think about before assessing what you want to do.
All right, next question is on my priority date is June 2015 in EB-2. Shall I downgrade to EB-3 or can I file concurrently for EB-3?
So it is.
Priority date is June 2015 for EB-2.
June 2015 for EB-2.
Shall I downgrade to EB-3 or can I file concurrently?
Right. So if it's if it's EB-2, then you would have to downgrade, right? So you can downgrade and file concurrently at the same time. That means you'd file your amended petition and you would file your adjustment of status at the same time.
Okay. Says if PERM and I-140 was approved for one location and moved to new location, do we have to refuel for PERM and I-140 from new location before filing 485?
Right. So first of all, I don't know why employers, if they're going to, if you know in advance, you can draft your PERM. This is just general information for everyone. You can draft your PERM in such a way that you don't, that you can move to various locations and it's okay. Now, remember, it's prospective. So if there is a way in which you may go back to that location, and there's there could be a bona fide offer of employment at that location, the employer is okay with you supporting that, then you can use that to file your adjustment.
All right. Next one, I have an employer A who applied EB-2 August 2013, but withdrawn before approval. Can he reapply now in EB-3 with previously approved PERM and I-485 concurrently in October and B in Q?
Right, so he filed it, but it was withdrawn.
Withdrawn, yeah.
Yeah, if you can give me the dates for that, email us at info@challalaw.com, and I can tell you, I want to know the date the PERM was certified, when he filed the I-140, and when he withdrew it. If you can give me those 3 dates and email me at info@challalaw.com, I'll give you an answer to that. Info, I-N-F-O, @challalaw.com.
Our next question is, once we get an EB-3 I-145 in future, if EB-3 does not move the GC level fast, can we go back to EB-2 and submit again?
Yes, you can toggle. Remember I said you can keep filing amended, or right now what you can do is file a new PERM, get an I-140 for EB-2, so you have 2 separate ones. And you can keep just, you don't have to amend, you would just submit a copy of the EB-2 as well. And so the regulations state that you get to benefit by whichever one is current, when it's with the same employer.
All right, here's a scenario where it says my EB-2 priority date is April 2012, and my spouse has EB-2 priority date of 2014. Which is better to downgrade to EB-3?
Well, one way to look at it is the strategy portion would be, because EB-3 2014 is going to have a longer, EB-2 2014 is going to have a longer time getting current. Now, if you look at historically over the past 1 year, EB-2 has just been moving like a day sometimes not at all. The big jump for final dates this month, a month and something, was probably the biggest jump it's had. So, you can either take the strategy that, hey, let me use my 2012 date and downgrade, and then I can amend back to EB-2 if EB-2 advances, because it seems like that would be the closest. Or you can file for your husband, but his is 2014, that's not going to become current anytime soon. So if you file for an adjustment based on yours, because it's spouse versus spouse, I think you may have to refile your adjustment all over again. So that would be the only issue that I would see. So I think, you've probably got a better chance of getting the earlier date advancing. And because you don't lose it, right? I mean, if you downgrade, you can always amend to upgrade, or you can, file a brand new PERM I-140 for the EB-2. So you will always still get to benefit from the earlier date. So that I think that that may be how I would think about it, is so I don't have to file a new set of adjustment applications.
The next question is on my I-140 is with my ex-employer. I'm currently working with another employer on H4 EAD. Can my ex-employer downgrade from EB-2 to EB-3 if I move my payroll to my ex-employer in this month, September?
You don't have to move your payroll to your employer to be able to avail yourself of this process. The employer does have to prove ability to pay. And 1 month of payroll, I don't know when you stopped working for that employer and you started working here, it would be an ability to pay issue. And if you go back, and we're going to have this recorded on, and we're going to upload it into YouTube. If you go back and look at the section that where I talk about ability to pay, you can show ability to pay either by, you have to show it from the date of the labor cert filing till your filing of the I-140. A downgrade is a filing of the I-140. So if you've been getting your salary from that employer and you haven't changed, the easiest way to show ability to pay is because you are being paid that salary or greater. If you're not working for that employer and it's a previous employer, remember they have to show all those years. So 1 month of being on the payroll is not going to make a difference. So you would want to find out and make sure that that employer can demonstrate ability to pay through his tax returns.
Okay. If you downgrade to EB-3 from EB-2, and if you work on an EAD, can you use your approved EB-2 I-140 to apply for I-485 if EB-2 becomes current? I think we have already answered that. Sorry. Do we need I-485J form from employer while submitting I-485 application?
I think they are requiring that right now. So I know at one point it was only if you had changed employers, but what I said I would do is check to see whether the I-485, the I-485 is not rejected. Like for example, you don't have an I-131. It's not going to get rejected for that. There's certain forms where if they're missing, you can always add later. So I'll check on that, join our Telegram group, because I'm going to post it on that group, the answer to that question about the J.
All right. I have an approved I-140 EB-2 category with November 2017 priority date. I recently moved to the parent company, a different FEIN, and got my H-1B transferred. I'm currently working for the new employer, basically same company that filed my I-140. Do I need to file new PERM, labor cert, and new employer with the new employer? If so, is filing under EB-3 advised?
Since your previous one was EB-2 and it's 2017, and it's not impacted by this whole thing, if the FEIN number didn't change and it's the same FEIN number, it could be that they are, one entity, but there may be various divisions. And so if you feel like, oh, I've got, even if you've got an EB-2 later on, you can always amend that if 2017 becomes available and do an EB-3. But if they're willing to file an EB-3 for you and you want 2 approvals, one in EB-2 and one in EB-3, then that may be something that you could do.
All right. I have an EB-2 priority date of 2013, planning to downgrade to EB-3. Can I travel before, during, or after? If it's advisable to not travel, can my wife, who is on H4, travel?
Right. So you can hold an H-1B visa and have an adjustment pending at the same time. So if your visa is valid, then, or her visa is valid, then the filing of the adjustment of status and you travel, it doesn't abandon your adjustment of status. It is only an issue when you don't have an H or an underlying L. So there's no restriction on travel once you file.
Okay. My filing date is current and it's EB-3. Can I submit I-485 without medical exam, or I have to submit medical exam report with the filing?
No, as I said earlier, medical examination is not mandatory. Do you want to take some of the raised hand questions
Yeah,
while we wrap this up?
I asked them to send, but I can have a, okay, next person, I think is Sanjay Pasupalati. If you can unmute him, because I can't. Looks like you can do it, I can't.
Okay,
Sanjay Pasupalati.
okay, let me. Okay, oh, sorry, wait a minute. Yes, Sanjay, go ahead.
I think he's still on mute. Got to mute him. I mean, you have to unmute him. He's still muted.
Yeah, I've unmuted him. I'm asking him to. I think he's got it on mute. Sanjay, you've got to unmute your mic, and you can ask your question.
Hello, ma'am. How are you?
Hi, how are you?
I'm doing good. I have one question. I am working for the same employer. My EB-2 is in December 2011. So I have asked him to downgrade to EB-3 and file for the adjustment of status. He said he'll be filing an amendment to EB-3. So if he files an amendment to EB-3 and it gets suppose approved, will I have EB-2 140?
No, if you want, you can always amend back to the EB-2.
Okay, so
but once the EB-3 is approved, that EB-2 I-140 no longer exists. It's been converted.
If it gets denied in EB-3,
then yes, then you still have
EB-2 140.
Yeah.
Okay, thank you.
All right, the next one you'd like to unmute is Satya B.
Okay. Hi, Satya. Oh, sorry. I think, let me see.
Hello.
Yeah.
Yeah, so my question is we are planning to downgrade from EB-2 to EB-3. So once my EAD and AP is approved, so if I go to India, can I go for the H-1B stamping because I don't want to use this EB-3 EAD?
Yes.
Is there any risks involved in that?
No.
Okay. Okay, thank you, ma'am.
You're welcome.
Next one is Karthik Dontula.
Okay.
Hello, Mr. and Mrs. Challa. Thank you for this opportunity and spending time and clearing so many questions of people stuck in this limbo. So my question, I'll try to be pretty simple and straightforward. So mine is June 2012, and I tried to downgrade it to 2013. So I understand once the EB-3 petition is approved, I still will have my EB-2 petition as well. But in the future, if the date progresses for final action under EB-2, can I switch back from EB-3 to EB-2 because I already got my 485 approved under EB-3?
Is your 485 approved or your 485 filed?
No, I'm just saying a future state because once
no. While the 485 is pending, as I said, there's something called toggling, right? So you have to file them if it's pursuant to an amended petition, you have to keep filing an amended petition, but there is nothing, because the regulations, the USCIS policy memo supports it, you can do that. You can, at a later date, amend back to EB-2.
So you suggest filing a new petition under EB-3 or amending the existing petition?
Well, you said yours is already, the adjustment's been filed, right?
No, not yet. I will start the process soon.
Okay, so you got to start the process soon, and you have to downgrade it in order to leverage the adjustment, right?
Correct.
Yeah, so do that under EB-3. What I would do if there's time and your employer will support it is file another PERM and I-140 under EB-2.
So my employer would support filing a new PERM, I'm sorry, filing a new 140, but not a new PERM.
Oh, okay, got it. But at a later date, you would just have to amend back to EB-2. If you
okay, so that's a possibility, right? Because I don't want to get stuck in EB-3.
Yeah, no, absolutely, that is.
All right, thank you very much.
You're welcome.
Okay, I think we have time till 2 o'clock. I think it's about another 20 minutes. So try to answer as many questions as we can. So I would request whoever is coming up to keep it brief so that we can answer more questions and more people. So the next one is Myrtle Sephora.
Okay, and what I will say to you all is within the next couple of days, what I'm going to do is just host webinars where all I do is ask questions. We'll probably have a limited group so I can have people ask questions orally. But if you don't get an opportunity now, you can either email us at info@challalaw.com or you can join the Telegram group and I'll try to answer those questions on there. Or you can join one of our webinars where I'm just going to be doing Q&A. Myrtle, please.
Good morning, Lakshmi. This is Myrtle's mother speaking. My name is Jessica. Actually, my daughter is a speech language pathologist, and she was applying for some jobs in California. Our doubt was whether we can apply for H-1B through multiple employers or should we only stick to one employer. That was my doubt, actually.
No, you can stick to, you can have multiple employers. That's not a problem.
Okay, because some said it's not legal, so I just wanted to get that clarified. Okay. Thank you. Thank you so much, Lakshmi. Thank you so much.
You're welcome, Jessica. You have a great day.
Next one is Ravi Shan. We have answered this question. I'm not
Yeah,
sure.
we've answered his question.
Let's go to Harish K then.
Okay, I may have to scroll down. Harish K, you said, okay, I see him. All right, Harish. Harish? Harish, you're going to have to unmute.
Yeah, I just did that thing. Hello, Harish? Harish, are you there? Well, let's go to the next one. Satish Kakarala, I think.
Satish. Find him.
SK, Satish Kakara.
Okay, I see it. I see it. Hi, Satish.
Hi, thank you. Thank you for helping us with this. So I posted my question here too. So is there, other than ability to pay, I'm in my 7th year of H1. So other than ability to pay, is there any other issue that we could face while downgrading this that could affect our underlying petition?
I mean, that's the, you want to make sure that your attorney kind of, there's certain language that they have to put in the petition when downgrading. There are certain boxes that they have to check off. The large number of denials that I've seen where other people have said, hey, we tried to do this. Here, this is what my attorney did. Can you review it and see what the problem is? And what I've seen in the problems is that the attorney, you have to request that you have to alert USCIS that you don't have the original PERM, and they have to request that. They don't do that. They don't check off the right boxes. You have to submit all the documentation supporting the original PERM, and then you have to show ability to pay. If you do all of that, you should be fine.
Okay, so I shouldn't be worried.
No, you just make sure that your attorney knows what they're doing, that they've done downgrades before.
So nothing on me is going to affect because it was approved before.
Yeah, I mean, in terms of, it should not, exactly. The only problem, like I said, that I see with downgrades is when the attorney doesn't complete it correctly, because otherwise they should be pretty straightforward. So that's the only thing.
And even in that case, we'll only get a reject on the downgrade and the underlying petition would still be safe.
Correct.
Thank you. Thank you so much.
You're welcome.
Okay, well, next go to Hardik Patel.
Hardik, you said Hardik Patel, okay. Hi, AFFIDAVIT.
Hello, ma'am. How are you? Thank you so much for doing such a great help at such a critical time. And my question is, I have my I-140 approved in both EB-2 and EB-3 with my current employer.
Oh,
My
good.
priority, yeah, with both the current employer, and my priority date is May 2nd, 2011, which is just barely in EB-2, frankly speaking. May 2nd, 2011.
Right.
So just thinking from an EAD standpoint, green card standpoint, what do you think to advise me? Should I go ahead and file under EB-3? Is that a better chance to get a faster green card, or EB-2?
Well, since you've got both, you're really not hurting anything, right? So right now you can file it under EB-3. If next month EB-2 advances, you don't have to file a new adjustment. All you have to do is send in your EB-2 I-140 approval notice to USCIS and interfile.
So technically, doesn't hurt if I select EB-3 for now, and in future, if EB-2 gets faster than EB-2, I just need to do that adjustment, you said?
No, you don't even have to do the adjustment. You have to do what's called an interfiling. This is what's so exciting about your case, AFFIDAVIT. You've got the perfect case because you can file right now, get the benefit of the adjustment because we don't know what the future holds. If by chance EB-2 advances, you do not, I repeat, you do not need to file a new adjustment. All you need to do is alert the USCIS and send them a copy of your EB-2 approval notice.
Oh, okay.
Isn't that great?
So yep, makes sense. So EB-3, you advise to do EB-3 for now, given the EB-3 may go faster, at least final exit date for some more time, at least maybe 2012.
Yeah, because if your employer has got an EB-3 and an EB-2 for you, you can't lose.
Okay,
so,
okay.
But we don't know, we can't predict that just because you're so close for EB-2, that November EB-2 will be available. There's a risk, right? So, and you don't have anything to lose at all. You know, if the numbers advance, great. You get to submit your EB-2. You don't have to even do a new adjustment filing. Your old adjustment is preserved. You just have to let them know you've got an I-140 for EB-2.
Oh, perfect. Thank you so much. Appreciate it.
You're welcome.
All right. Let's go to Kiran Ravikanti.
Okay. Hi, Kiran.
Hello, Lakshmi. Hello, Shekhar. Thank you very much for this opportunity. Appreciate all the hard work that you're putting in. So my question is, my priority date is December 2010 in EB-2, and I am current in EB-2 and EB-3 as well. Fortunately, according to the data filing, but right now I'm in between the jobs. Right now I'm leaving my employer and joining a new employer. So my question is, it's a lateral move. Even if I were to downgrade to EB-3 or stay as is to EB-2, what is recommended, and any gotchas that I need to watch out for a lateral move from a development to architect?
Right. So when you say so you're having a growth within your own organization, is that what you're saying?
I'm moving to a different employer altogether.
So is your previous employer willing to support your green card?
Yeah, they're okay, but they would go by the book. I'm working for, I'm working for IBM and then moving to another company.
Okay. So yeah, they're, and then, the IBM, clearly you're not going to have an issue with ability to pay. So you could downgrade with IBM and let that process go, because you said that you'd have to downgrade in order to leverage, or did you say you had two?
So I'm in between the jobs. I'm going to join a new employer.
Right. So your I-140 with IBM, is that an EB-2 or EB-3?
EB-2.
EB-2. So it's EB-2, it's dates of filing is eligible for EB-2, or do you have to do a downgrade?
I am eligible for EB-2. I don't have to do a downgrade.
Right. And so if IBM is willing to do that, then go ahead and, you know, have them move forward with that. There shouldn't be any issue.
Yeah, since it's a lateral move, would it be a problem? Because, you know, if I were to be in a better position from a green card point of view, it's a future employment, right? So I wouldn't be looking back to go into a individual contributor role.
Right. So, you know, once the I-140 is approved, as long as you intend to do that now, once the I-140 and 45 is, I mean, once the I-140 is approved, and the I-140 is already approved, right? So you don't even need to do a downgrade. So once a 45 has been pending for 180 days, you can change to same or similar employment. It doesn't have to be same, it can be similar. So it can be a higher grade than what you're doing now, and you just port.
Okay, all right, thank you very much.
You're welcome.
Okay, I'm going to get 2 more questions before 2 o'clock. So the next person on the list is Neha Raleigh.
Hello, Neha. Neha, you're going to have to unmute.
Okay. Hi, can you hear me?
Yes, ma'am.
Yeah. So I had a quick question. I mean, my lawyer has asked me to fill the I-485 and things and then send him the copies of everything. I saw that there were new forms that were coming on 2nd, but today morning I saw that there was a federal something and the file, you know, the fees has not been increased.
Yeah,
so when I filed,
the fees haven't been increased, but there will be some new forms.
Okay. So still we have to use the new forms after October 2nd, but we can use the old filing fee. Is that right?
That's what it is of today. We don't, you have to, something you got to keep checking on because sometimes they change it, you know.
Okay.
It's the president that's trying to move this. It can be moved fairly quickly. But the forms will definitely be something I would watch out for, because the forms have to be the forms that they will accept on the date of filing. So it's not when you fill them out, it's when you file it. So if there's a new form, updated form, then you've got to make sure that you've got the updated form when you file. Otherwise, it'll be rejected.
This is
my husband Mahesh.
Yeah. So quick question. So on the website they said that you know, after August 25th, if you use the new form for I-765, then they will automatically reject it. If the mailing date or the postmark date for the form is after August 25th, it will be a problem. So and they have not put the new forms yet. So what do we do?
Right.
Like fill the old one?
Yeah, and that's slightly different, because what they did with that is that was related to the fees.
I see.
Because before, the I-765 and the I-131 was part of, it was included within the adjustment.
Yeah.
Okay.
And they broke it separately. So what I would suggest is we're probably going to have a memo out on this so people know exactly, because it's, you know, some of the forms do get updated, some of them do not. But if you join us on the Telegram group, I don't know if you're part of the Telegram group, but we'll be posting updates on that so people know exactly what form that they need for filing.
Another thing I need help was with the list of documents for the I-944 form. People are saying me a lot of things that is required. Is it possible that you come up with a list and put it in Telegram or something?
Yeah, we put it on our, I think Kara shared it on the Telegram group.
Okay, so I'm going to join the Telegram today and I'll see, and then most probably I can send you a message that time. Thank you. Thanks a lot.
You're welcome. Good luck.
All right.
Thank you so much.
So it's getting close to 2 o'clock. So the last person on the list. So once again, we apologize, time constraint, but like Lakshmi said, you know, you're welcome to send an email to info@CHALLA'S if your question was not answered specifically, or join the Telegram group, which she's already got the link, you know, up there. So the last person today, and again, We do apologize, we have time issues. Is Aniket Sinker.
Aniket?
Aniket Sinker.
How's Sinker spelled?
S-I-N-K-A-R. Aniket, A-N-I-K-E-T.
Okay, yep, got it. Hi, Aniket.
Hi, Lakshmi. Can you hear me?
Yes, sir.
First of all, I appreciate both of you, Lakshmi and Shekhar, for doing this call for us and providing clarity on what the situation is. I have this strange situation where I actually used to work for my current employer from 2010 to 2018. They had filed my PERM and had their 140 approved in EB-3. So I left the company in 2018 and joined back in 2019. So 2019, so somewhere around April, they started my new PERM. The PERM in EB-2 is in process right now. It's not been approved.
Okay.
But I do have my old 140 in EB-3 with them from my previous stint with them. Can I use that?
Absolutely. That's perfect. And you can use that. You don't have to show ability to pay because the I-140 is approved and it's with the same employer and you're not making any changes to it. Continue with the PERM under EB-2. If the numbers, once the EB-2 is approved, if the numbers advance for EB-2, you'll be able to interfile it without having to file a new adjustment.
Awesome. So the company can still use my older EB-3 and just get my I-485 and other process started. Awesome. Thank you.
Yes, good luck. That's fantastic news. And Ankit, if you enjoyed our program, please.
I've already signed up for your Twitter. I'll get the Telegram, join the Telegram as well. So
yes, and please share it with your friends. And what we're going to do for all of you that are still hanging on, I think we had close to 200 when we started, is I'm going to have smaller groups of webinars, and all I'm going to do is Q&A, so that I can answer everyone's question, and in person, because that way they can explain better than when they write it out. And we'll try to look at the Q&A questions today, and whatever we couldn't answer, we'll try to get that, some of those answered and send that out to you. Our goal is to make sure that your process goes as smooth as possible. And we wish all of you the best of luck. And, look out for our additional webinars where we're just going to do a question and answer.
Thanks a ton, Lakshmi and Shekhar. Appreciate it. Thank you. Bye.
Bye.
Thank you all. Lakshmi, you want to conclude?
No, I just had said that we're going to have, if you didn't get a chance, I'm going to host shorter webinars where, and we'll put some dates up so that we can make sure that people are not signing up for this. The same people are signing up, so more people get the opportunity. And I'm just going to do Q&A. So you'll be able to ask your question in person rather than having to write it up. And we will look through the Q&A questions that were asked, and we'll try to post those, some responses to that. Join the Telegram group, because we're going to be posting a lot of these resources on that, and share that with your friends. And you all have a great week.
Thank you.